Hi, everyone. So we're going to get started. Welcome to our August Elder Abuse Task Force. We're really excited you could all join. Great. So starting with our mission, API Legal Outreach was founded in 1975, and the mission of API Legal Outreach is to provide culturally competent and linguistically appropriate legal representation, social services, and advocacy for the most marginalized segments of the community, including low-income women, seniors, recent immigrants, and youth. And now a little bit about our Elder and Disability Rights Project. API Legal Outreach's Elder and Disability Rights Project offers comprehensive legal services to elders and individuals with disabilities, focusing on securing public benefits and preventing abuse. Our team works with community partners to ensure accessibility and provides legal services in areas including immigration, elder abuse, estate planning, housing, conservatorship, and protective orders, to name a few. We are committed to both preventing abuse and supporting survivors through our dedicated attorneys and staff. And a little bit about the Elder Abuse Task Force specifically. The Elder and Disability Rights Project at API Legal Outreach convenes monthly forums uniting government officials, community members, and legal professionals to address challenges facing elderly and disabled individuals in the API community with a focus on combating elder abuse. And just a few housekeeping rules before we get into the presentation. If you could please mute your microphone when you're not speaking and to minimize background noises. And if you could use the chat function for questions or comments, we will have questions. We will have time reserved for the questions towards the end of the presentation. And if you'd like to ask a question, please use the virtual hand function to let us know. And also, if you're experiencing any technical issues, please try reconnecting. But if you're still experiencing those issues, please email us at the email that's listed on number 6. And finally, as I mentioned, the questions will be answered towards the end by the speakers. So please do include those in the chat, or we will ask you to unmute yourself and share them at the end. And now to introduce our speakers, we're really excited to have Tony and Arabelle from CANHR today. So I'm going to tell you a little bit about both. Tony Chicotel attended Shawnee Elementary School in Herren, Ohio, and made his mark by taking down all comers in the 50-yard dash. As a boy, his proudest moment was hitting a triple off Demetrius Brown in a Little League All-Star game. But full disclosure, he was thrown out trying to stretch it into a home run. At age 17, he read a book called The Terrible Truth about lawyers and immediately wanted to become a lawyer. He has fought for the rights of long-term care facility residents for 22 years through litigation, legislation, regulatory policy, and consumer education. Tony's focus area include civil rights, eviction defense, dementia care, incapacity and decision-making, conservatorship, and end-of-life care. Tony loves hugs, milkshakes, and sleeping in, and hates Costco parking lots and tucking into shirts. And we also have Arabelle Malinis, who has dedicated her career to advocating for the rights of the most vulnerable people for over 15 years in legal services and private practice. Her expertise in elder law and estate planning is a cornerstone of her work as a staff attorney at California Advocates for Nursing Home Reform. Here, she provides comprehensive advice and training on a range of topics related to older adults, including eviction defense, Medi-Cal, incapacity, and elder financial abuse, among others. Before her tenure at CANHR, Arabelle practiced estate planning, trust, probate administration, and litigation, and served as a day-of-court mediator in unlawful detainer cases. She also gained experience in consumer protection, foreclosure defense, and fair housing at Housing and Economic Rights Advocates. Arabelle's diverse interests include trail running, kickboxing, traveling with her family, and reading a good book. So Tony and Arabelle, we are so excited to have you. So now we will turn the floor over to you.
Thanks a lot. Appreciate the opportunity to talk to you. Arabelle didn't put this in the bio, but coincidentally also hit a triple off of Demetrius Brown in a little league game way back in the day. Didn't you, Arabelle?
I
Oh.
don't know.
You,
You're
did
up
you
to
have you ever
bio.
hit a triple?
I don't know what that is.
Yeah. Oh, I can't believe I haven't rubbed off on you more on this call. Okay. Yeah, so I just wanted to give you a little rundown on CANHR.
Okay. Oh, yeah.
Yeah, can you put the screen,
Yeah.
the
Yep.
slides up?
Yep. Start. Okay.
I know some of you are familiar with what we do. Maybe not the full extent of what we do, because we do a fair amount. We have about 12 staff people. We cover the entire state. We do mostly long-term care related issues. Um, I think our real bread and butter is people calling us or emailing us or getting through to us through our contact form on the internet and letting us know that they're having a pretty bad time with their long-term care experience and they're asking for help. Either they've been suddenly thrust into requiring long-term care and don't really know how to do the shopping part of that, or more likely than not, they're already in the long-term care system and things aren't going well, and they want to know how to fix them, whether they're correct in assuming that things are wrong, and if they're wrong, what they could do about it. So, a lot of advice and counsel, real quick, 20-minute, 15, 20 minutes, sometimes 30-minute calls, a lot of email replies. Hey, here's the answer to your question. Look at this regulation, look at this guidance that the regulatory agency issued back in 2018 or something like that. A lot of times those issues involve evictions. Hey, they're trying to throw me out, usually because they can make more money by bringing someone new in. We do a lot with that. We also deal a lot with paying for long-term care, particularly government benefits, primarily Medi-Cal coverage, and managed care coverage for long-term care services. And then we also dabble in some financial elder abuse stuff. When we have real significant injury cases or death cases in long-term care facilities, we have a state bar certified lawyer referral service. We refer people to those attorneys to potentially file cases. We also have an estate planning lawyer referral service. We have about 80 different fact sheets on our website to cover all sorts of different long-term care issues that we refer people to. And we also do a lot related to just, I call general elder law practice, advanced healthcare directives, estate planning, end of life things, hospice care, yeah, that kind of stuff. All right. So if you want to check it out, go to our website and you can see a lot of great information about long-term care. All right. So this is what we're going to talk about today. We're going to talk about capacity, representing people with impaired cognition, maybe a cognitive disability. They may have some trouble making decisions. They may have been alleged to have trouble making decisions, but you find out otherwise. But I wanted to tell you what I think the two themes are, at least from what I'm going to talk about. I think the two themes are there is a lot of corner cutting in capacity assessments and in judging people's capacity. And what I mean by that is older adults, I think, are subject to a lot of bias and sometimes outright discrimination. People see an older person and oftentimes think of they associate that with disability, which is really wild, and a lot of times cognitive disability. And um, in my experience, and my experience is very um, unique, and that most people call me because things aren't going well. So I'm brought into a lot of situations where things are not great. But in my experience, um, folks come in, they say, oh, there's an older adult, they're having trouble making decisions, and they assess that capacity, and they're already leaning towards finding they don't have capacity. And then they just go and do the things that sort of confirm that pre-existing idea and don't give it a whole lot of thought. Even physicians, I think, maybe especially physicians, can be guilty of real quick assessments done in 10 minutes or less on one particular day and they don't get a full appreciation for this person's capacity. And then they're making determinations that could affect this person's rights and their ability to manage their money and um, join in a lawsuit or things like that. So it's pretty important stuff. And then so that's the first thing, a lot of corner cutting, and we'll get into more specifics about that. And then my other theme is that almost everybody that I've ever talked to, even people with profound cognitive disabilities, have some level of capacity to communicate unmet needs, to communicate preferences, to communicate likes and dislikes. Sometimes it's not with their mouth. Sometimes it's with their actions, and their facial expressions and their body language, what they're thinking. But almost unless you're in a straight out coma, almost every human can convey preferences and what's working for them and what's not working for them. So I really hate the idea like, oh, incapacity, meaning suddenly now you can't make any decisions and you have no input in these decisions that affect your life. I think that's disingenuous. Everybody should have some input and should be told what decisions are being made and allowed to have some input in what goes forward, even if they don't have the legal capacity to make those decisions. Okay, so I'm very pro capacity. Next slide, please. All right, so let's get into it. This is, I think, for my purposes, the most important slide I'm going to cover today, the difference between capacity and competency. And some people, a lot of people are uncomfortable with the term competent or incompetent, but I like to keep it because I like to refer to it because it's has a very specific definition that's important for lawyers to know. So capacity, that's, do you understand what I'm saying? Do you get it? I think lots of people have ideas of what capacity looks like, but competency is a very narrow concept, and that is the legal ability, the legal capacity to make decisions. So capacity, anybody can make a capacity assessment. I've done them. Perhaps you've done them. If you've not done them, formally, you've probably done them informally, just when you talk to people. What's their capacity to understand what I'm telling them? A child, for example, less capacity, you might want to keep your communication more simple and slow and more direct. So we do capacity assessments all the time. Competency is a very specific concept with probably going to be determined by a very specific instrument. And in courts, we have burdens of proof and standards to prove competency or incompetency. All right. And what makes this so important is someone may say, well, the doctor says you don't have capacity. Well, okay, that doesn't legally mean anything, usually. But if a judge says I don't have capacity, now that's an incompetence determination, and that's probably going to impact my ability to make some kinds of decisions over my life. So that's why I'm making such a big deal of distinction. I don't care if someone's been determined to lack capacity. It's not preclusive. It's not legally preclusive of anything. Competency is what I'm concerned about. That's when we start getting into infringing people's rights. All right, next slide. Really important starting point, California law, statutory law recognizes that all adults have capacity to make their own decisions. If we're trying to do something against that adult's wishes, the burden is on the other party to prove that they don't have that capacity. This is in Probate Code 810. Probate Code 810 is the beginning of the Due Process and Competency Determinations Act, the DPCDA. And they get into some legal standards of determining competency in California courts, but it starts with 810, and 810 says, we presume all adults have the ability to make their own decisions. If we're going some other direction, you have to prove it in court. Does that make sense? All right, next slide. What do we got here? Okay, this reinforces what I talked about earlier. It's a court. If we're talking about affecting someone's rights, their ability to make their own decisions, the ability of someone to overrule the principal in a decision, it's got to go through the courts. There are some exceptions to this. I'm thinking the most obvious one is, for me, is the Welfare and Institutions Code 5150 behavioral hold process. In that situation, you can override someone's preferences related to their decisions. You can, physically move them off out of the public sphere, out of their private home, and into a mental health facility. But the process is very prescribed. You have to have only certain people can initiate the process. There has to be a certain determination. It's only good for 72 hours, so it's of limited duration. And then you get the right to additional processes. There's not many exceptions to this. Normally, you got to go to court if we're trying to physically force someone into treatment or trying to overrule their own decisions about their own lives. And this is really important. Doctors don't trigger incompetency decisions that affect your rights. In the 5150 process, they can. And again, there are some exceptions. I'm thinking in advanced healthcare directives, a lot of times the principal retains the ability to make their own healthcare decisions. But if a physician finds that they lack capacity, then the agents are empowered to make their decisions. In that case, a physician's determination of capacity does have some legal value, but we also know in the probate code, if the principal says, well, that may be what my healthcare directive says, but I don't agree with it anymore, and I don't want this person making decisions for me, they rule unless you go to court and take away that ability. All right, next slide. So this just another legal standard, a statutory standard for capacity determinations in the context of conservatorship. Conservatorship is a unique legal process because it brings in both the clinical determination of capacity, and that's what this probate code section is focused on, doctors, medical assessments. But the standard for a conservatorship is very pragmatic. It's all about outcomes. Can you meet your needs? It's not, oh, you have very advanced dementia, therefore you meet the requirements or standard of proof for conservatorship. You could have very advanced dementia and still not meet the criteria for conservatorship because you still have your needs met. You're able to meet your needs either through your own abilities or the abilities of people that help you and are set up to help you. So third-party assistance can defeat the criteria for a conservatorship. So that's interesting. The other part of conservatorship that I find really fascinating, and that if you can go to the next slide, Arabelle. If you look at this, a very process-intense formula for determining capacity by a judge, and that's what we want. If we're affecting people's rights, we want to make sure that the decision is a good one. There's a lot of evidence that's weighed, and we have very clear burdens of proof. What this chart shows me is flexibility. And we're looking at, are there any less restrictive alternatives in any point of this process? And if they are, we're trying to avoid conservatorship. We're trying to have the least amount of intrusion on people's autonomy, and that's great. And I love this flexibility, but it's weird in the conservatorship context because you have all this flexibility, there's lots of wide varieties of capacity among people, independent of diagnosis and independent of disability. But conservatorship is ultimately a really binary, in my experience, a really binary determination. Either you have capacity and there's no conservatorship, or you don't have capacity and now there's a conservator who makes a lot of decisions about your health and well-being and your finances, and you've basically been, relegated to the state of a child legally. So conservatorship, I think, could use a lot of reform in terms of how powers are awarded to conservators. Judges have the ability to, go a la carte with the powers, but they rarely do. They usually check the plenary powers. I think there's even a reference to it in this chart. Yeah, under number 4, make determination, it says use plenary guardianship. Plenary means give them all the powers. Is that necessary? I don't think in most cases it's necessary to give full plenary powers, but that's the standard because I don't think the judges are really interested in having conservators coming back time and time again to get additional powers. All right, next slide, please. More on capacity standards. And what I want this slide to convey is that it really depends on what we're asking the principal to do. So when people say, does he have capacity? The answer is always capacity to do what? It depends, right? It depends on what we're considering. It's not an open-ended question. There's lots of different kinds of capacity, and the law recognizes this. Testamentary capacity is different from contractual capacity, which is different from healthcare capacity. Healthcare capacity, we're thinking about, can you understand the risks, the benefits, and the alternatives to this medical treatment? Whereas testamentary capacity, I think, is a lower standard, where it's just, do you know what you have, and do you know who you want it to go to? If it makes reasonable sense, then yeah, you probably have testamentary capacity. All right, next slide, please. And this is where Arabelle comes in. And Arabelle, I don't know if there's anything else you want to say about what you do at CANHR, what, any more on your biography, but if you want to, you could do that now.
Oh, not really. I think I
Okay, we
covered
got
it,
it all.
but thanks. So I'm going to talk about ethics and best practices. There's going to be a lot of it has references of lawyers' ethical obligation under the rules for professional conduct. But I think of it for the non-lawyers out there, think of it as like a guidepost, because I think that it's really good to have this kind of framework when you do encounter or deal with clients with diminished capacity. So we do have as attorneys there is a formal opinion, State Bar Standing Committee, on working with clients with diminished capacity. Essentially, it's the lawyer should make it reasonably possible to preserve the attorney-client relationship, and that the lawyer does have an ethical obligation that it doesn't change the way they treat people with diminished capacity doesn't change their ethical obligation. However, they do need to provide accommodation to these people. And they have to take reasonable steps and additional measures to ensure that clients' decision-making power authority is preserved and respected. So there are 4 different ethical rules that are highlighted when dealing with diminished capacity. It's competence, duty to communicate, duty of loyalty, non-discrimination. And then I'm also going to discuss, since you deal with people that have language differences, that part too, and the lawyer's ethical obligation to people who are limited English speakers. So that's going to be in subsequent slides.
I'm sorry, Arabelle, can you go back?
Oh yeah. Okay. Yep.
One more.
Oh, okay.
Yeah, I just wanted to mention here because I was invited to speak to a different legal services provider earlier this year, and the executive director said, I'd really like you to focus on, we're talking about capacity, sort of demystifying speaking with clients or potential clients with cognitive impairment. And she said that a lot of especially the newer attorneys and some of their volunteers were a little daunted by the idea of meeting with clients who might not have full cognitive capacity. And I understand that. I get it. It can be a little more difficult for communication and time consuming and require a little more skill. But these are the clients I mean, if you do legal services, these are the clients you want to help, right? The people who are perhaps most vulnerable to abuse and neglect and other bad things happening. So this professional rule, and there's lots of other ethical canons that talk, hey, people with cognitive impairment should get the same kind of representation that any client gets. You might have to make a few accommodations here or there, but these are our people, right? This is who we want to help. And to me, these ethical obligations are really reinforcing that we can do great work for these folks.
So the first one is duty of competence. I think Tony already discussed about this. I don't, people approaching people, especially people that deal with older adults sometimes, and I've seen this with dealing with other professionals of this like paternalistic view of older adults, especially old, and there's already an assumption that someone lacks capacity because of their age. But as an attorney and as professionals, you have to inquire about them further than that. And there has to be a heightened sense of awareness to the needs of the client. And part of it too is implementing, understanding that the supportive measures that are available and implementing those measures for those clients. There's also something to think about is informed consent. When sharing the information, having the client really understand the nature of their case, and so they can consent. And then another ethical rule is the duty to communicate. Just like with, clients who don't have diminished capacity, you also have a duty to communicate with people with diminished capacity, but it's another layer to it because you have to ensure that there's effective communication, and then you have to consider measures to facilitate that communication. And it says explain a matter to the extent reasonably necessary to permit the client to make informed decision regarding the representation. So the duty to communicate, one is so that you to be able to effectively communicate so they can have the information to give informed consent. And then another is avoiding conflict of interest or duty of loyalty. It requires lawyers to act solely in the client's best interest and protect the clients every possible way. They have to must exercise independent professional judgment, avoid paternalistic and set aside conventional prejudices. Another thing too is that when you have family members involved, there could be additional conflicts that are there. And, there's also multiple narratives in these cases where it's like you have a lot of very emotional cases with, family issues. And so, making sure that, you keep in mind that you're acting solely in the best interest of the client and setting aside, third parties, views of the case or even your own, prejudices and being aware of that.
Yeah, and I'll add there that I think one of the more unique aspects of an elder law practice is the fact that there is often a third party at the meetings, sometimes more than one. There's family members who provide the transportation, maybe provide some communication assistance, and a lot of times important support for the client. But you got to be really careful when there's other people in the room. We'll get in more into the concerns there, but I think this is very common in an elder law practice is that there'll be other people with your client who want to stay in the meeting and provide information and get information to the meeting. You got to be really careful about, whose interest they're pursuing.
And then the other one is non-discrimination. So of course, not discriminating against people on the basis of protected characteristic, including disability, which includes diminished capacity, but also requires reasonable accommodation. And I discussed that before with the competency part because they all kind of go hand in hand. And then failure to make reasonable accommodation is in violation of the ADA and their associated laws. So another thing that you probably see more with your clients is clients with limited English proficiency. So there are ethical rules for that. I mean, understanding that there's language barriers that could that could prevent from gathering complete comprehensive information or misunderstanding. And then added to that, there's language differences, cultural factors, and they have different systems of laws and the court systems in their countries. So there's, the competence, the duty of competence, as well as communication. And so the same, similar, different, so similar ethical rules, but applies even more so additionally to people with limited capacity. So in like duty to communicate, communication, the lawyer that does not speak the same language, you have to understand how do you be able to provide, how do you provide information to the client so they can understand like the technical documents, the legal, the language, the words, that sometimes it varies between like languages, and also fundamental legal concepts that may not be exposed to, like lawyer-client relationship, like duty, like confidentiality between lawyer and client. So there is guidance, and it's an ABA Formal Opinion 500 that was issued in 2021. And this opinion says that when there are language considerations affecting the reciprocal exchange of information, a lawyer must ensure that client understands the legal significance of translated or interpreted communication. The lawyer understands the client's communication. So there has to be a two-way communication. It has to be understood. There has to be, keeping in mind, potential differences culturally, socially, that would impact the meaning of the communication. So I wanted to bring up this hypo that I've encountered in my practice, where it's Clara, who's an older adult, comes to your office with a daughter, Diana, to report her son, Stephen, that he's stolen a lot of money from her bank account. She's asking for help. Clara's primary language is not English, and you do not speak the language. Dana and Stephen do not get along and has already shared with you how awful her brother is. Diana also offers to be an interpreter for Clara. What are the best practices in this situation? So here. In this case, the attorneys, they have to go through what the ethical obligation is, Rule 1.1 and 1.4, competence and duty to communicate. So figuring out, how can I communicate effectively to the client with limited English proficiency? So would Diana be an appropriate interpreter? Maybe not. I mean, she has her biases, right? And so she already expressed to you that she and her brother don't get along. And so she probably wouldn't be the best person to be able to translate, to be able to interpret the meeting. And we get this a lot, and like sometimes in our case, and sometimes what Tony also said, with like in terms of shortcuts, some people, it might be the easiest, right? If you don't have, staff or anybody else to be able to translate, but it's really important to think about how to really focus on the best interest of the client, to be able to first of all make it clear that the client, the older adult, is Clara, is the client and not Diana, and to be able to meet with them separately without Diana there. So, and then another issue is, what if the staff in your office speaks the client's language, which is great and often is the case. But then as an attorney, you have to also think about the skill level of the staff to be able to accurately convey the information to the client, including understanding, the legalese, and being able to translate that to the client so they can understand. And attorneys do have supervisory authority, and they have to make reasonable efforts to ensure that the person's conduct is compatible with their staff's professional, or their professional obligations. So duty of confidentiality. Another thing.
Can I throw in
Yeah,
here,
yeah,
Arabelle?
yeah, sure.
It's a good hypo, because I am really uncomfortable. I would be really uncomfortable going forward with Diana serving the role as interpreter, translator for Clara, because maybe Clara stands to benefit, or I mean, Diana stands to benefit from Clara being more careful with her money because that enhances her inheritance. Or maybe Diana's also living, rent-free at mom's house, something like that. There's concerns.
Mhm.
And a lot of times, in my experience, older adults will be, I'll be led to believe that there is a son or daughter taking massive advantage of them, especially financially. And then I talk to the older adult alone, and they say, yeah, I know, but I love them. And this ultimately, like, I want them, I want to be generous to them, even if they feel like they have to be deceitful to get this money from me. I don't mind them having it. In other words, it's in some regards they're okay with the situation. They don't want it to be different. But now if I've got Diana interpreting, I'm not sure I'm going to get the full the accurate answers from Claire that I would hope in terms of the relationship with Stephen. They may, there's a lot of just room for being misled in that conversation with Claire.
Another
The daughters
consideration
tend to.
too, if is Diana is the caregiver and Clara heavily relies on her too. And so it's like, that could, and Diana is present in the room and you see Clara looking at her, if you're out, you're talking, that could happen. And so just taking Diana out of it so you can actually talk to Clara alone.
And
Yeah.
yeah, with a lot of people, but especially older adults who have maybe a cognitive impairment,
Yeah.
just the way you frame the questions,
Yeah.
a lot of times is going to predetermine what the answer is going to be. And if you're not speaking this second language, you're not sure how she's framing the questions. It's just rife with potential problems.
Yeah. So we have technology, right? Like our technology has advanced dramatically. So I've actually seen in some cases Google Translate or another translation technology. But then with technology, just consider that it's not going to catch nonverbal cues or tone in the translation process. And also it leaves out like the cultural competency part that's not captured by technology. So under like with the ABA and just, it just common sense wise, professional interpreter or translator, if it's your staff, that's great, is preferred. And then keep in mind for attorneys, California Civil Code 1632 requires that most consumer contracts, including lawyer retainer agreements, have to be provided in the language at the first language of the client. So that and that includes retainer and conflict of interest waivers, and the languages that are required in California are the one, two, is that five? Spanish, Chinese, Tagalog, Vietnamese, and Korean. And then what if it's, a person with limited English proficiency, but also with a disability like Alzheimer's. So you have to really keep in mind all what we discussed about the different different duties for attorneys, like the duty of confidentiality, duty of competence, conflict of interest, and non-discrimination, along with the language consideration, and then also other accessibility requirements under the ADA and Cal Civ Code Section 54. So that's you, Tony.
Yep. Okay. Now we're talking about assessments and some more case scenarios, real practical stuff for when you have a client with a cognitive impairment in your office or on the telephone, what you should be thinking about and maybe what you should be doing. So a lot of times you'll have some indications that this client may have potential cognitive impairment before you even meet with them, just on the intake. Maybe the nature of the request for assistance is such that they have to have a cognitive impairment. So I'm thinking one scenario where it's custom for me to be starting to think about the client's capacity is when they're asking to do estate planning, particularly incapacity planning. What prompted this? Did you get a diagnosis? Are you there's some symptoms maybe of some short-term memory loss, and now you want to get your affairs in order in case you have progression and there's more and more capacity concerns. So these are the things you want to take a look at the beginning. Interviewing the client alone, I think, is imperative unless there is that language barrier situation. You see there's some asterisks on that one. There's a really good guide from the American Bar Association called Why Am I Left Alone in the Waiting Room or something. It's for family members of potential clients to get and read while you meet with your client alone, that explains why we have to meet with them alone. Does a good job of summarizing that, and then you don't have to have that maybe you can avoid some of that conversation yourself and save some time. Or you can just use it as a reference for yourself for your conversation with that person as to why you're meeting with the client alone, at least at the beginning. Doesn't have to stay with them alone, but you want to make sure that, hey, this person isn't dragging you in here. You know why you're here, right? You're not being, I don't think you would ask it quite this way. You're not being unduly influenced, coerced to be here. I just want to hear from you as to why you're here, and make sure that you want my help and that I can provide help for you. I think we had in here when a formal assessment is needed. I'm going to have another slide on that coming up in a second.
Okay.
But definitely any client you meet, whether there's reason to believe they may have a cognitive impairment or not, you want to make sure that they understand what you're doing and that they're authorizing you to go forward with some sort of action on their behalf. It's critical to establish capacity for every client. All right, next slide, please. So some of the things that I think you would understand are pointing to diminished capacity. And these are things you could ask your client. I think more likely you're going to get better answers from maybe the person who brought them in, or family members that you could reach out to for additional information to assist them in their case. Hey, are you noticing these things? If these things are coming up, then you might want to move on to another step in establishing a more formalized capacity assessment so that you can go forward and do the work. What I wrote in my notes on this slide is engage. I think it's so important to engage with the client, have a conversation with them. And I think for the most part, you want them to do most of the talking. You want to ask them a lot of open-ended questions. Why are you here? Tell me about your relationship with your family. I think this is perhaps the most important question. What do you want? What do you want me to do for you? What do you want to get out of this relationship? What do you want to improve in your life? Why, you don't go to see a lawyer unless you got some sort of problem. Oh, tell me about your problem and tell me how you want to resolve it, and I'll see if I can help you get that. So engagement, just a lot of engagement. Next slide, please. Okay. Definitely want to maximize your chance of success for having a good interaction with the client. So you find out, hey, is it better for you in the mornings? For some people, that's the case. Is it better for you in the afternoon, later in the evening, things like that? Are there certain days that might be better than others? I find I did a lot of client discussions in their homes. I did a lot of home visits, and I just felt people were more comfortable in that environment than they would be in an office. But for some people, I really think that they felt more forthcoming in my office for some reason. Like now they were out and formalized the interview and made them feel like they had to provide more information. I think that was true for some folks. Definitely want to have enough time scheduled. Open-ended questions, I already talked about that. Multiple meetings. I think that's really important here. If things don't go well that first meeting, hey, maybe it's just a bad day. Maybe they're on a new medication. Maybe in my situation, I'm in a nursing home a lot. Maybe they just got done with their rehab. They were in 90 minutes of rehab and they're tired. Maybe they hadn't had lunch yet, whatever it might be. So a second meeting, I never would say, oh, clearly you don't have capacity. I'm not going to be able to help you. It would be like, let me come back in a week or two and see how things are going then. So if you have reason to believe that capacity is a problem, you want to be doing a lot of documentation. If you're going to ultimately represent this person or execute documents on their behalf. You better have evidence that they knew what they were doing. So you want to jot down how they answered those open-ended questions and what your assessments were, your observations were. Was their sense of humor intact? How was their short-term memory? Did they need a lot of prompting? Were they able to repeat things that you told them once you explained things? That kind of thing. So I also wanted to show you, so this is my chance to show you what could be useful to you is a mini mental status exam.
Do I need to stop share?
Oh, yeah.
Okay.
Okay, so let me throw this up there. Some of you may have seen this. If you haven't, you just Google search mini mental status exam. There's a lot of, they're all pretty much the same thing. I think a version of this is the Montreal Cognitive Assessment, the MOCA, which I think President Trump took in his first term and like was really proud of like his great success in passing the MOCA, which says a lot. Flying colors in a cognitive assessment form. Anyway, so this is the kind of stuff you could use when you engage with clients, and you could do it informally, just sort of, in some cases it's a little infantilizing, maybe asking these questions. So you wanna prime them. Hey, we're doing some pretty sophisticated documents for you. There is reason to believe that somebody might try to challenge these documents. We want to make sure that we have your capacity locked down. It helps us protect this document that you're about to do. So if you don't mind, I'm going to take you through this quick assessment form just to make sure this is one more thing I can add to the file that establishes you had capacity and will protect the validity of these documents. Does that sound cool? Okay, great. Let's do this. I know it sounds silly. Count by 7, serial 7s down from 100, spell world backwards, those kinds of things. You don't have to make it this formal. Hey, who is the president? What year were you born? What's the month today? How's the weather outside? You can ask these things and make notes on your own. One of the let's see, I don't think they have the clock on here. One of the common assessment tools or questions they use is clinicians use is to have a client draw a clock and then set the hands for a particular time, like show me 7:15 on your clock. And I guess that's a really good way of determining where someone who might be presenting as having full capacity, you might find that they are having some cognitive trouble when they're asked to do the clock thing. So that's something you might want to try. So just thought you might like to see that. The mini mental status exam. I used to do those in my office. If we were doing estate planning documents and I had reason to believe that someone might challenge whether the testator or the trustor had capacity to sign them, I would throw in a mini mental. And then there's a scale, you can assess the points. Okay, can you go to the next slide, Arabelle? Thank you. So these are the situations where you might want to do a mini mental. Big money, you got a family fighting with one another. You got the Diana versus Stephen case. There's just a lot of signs of cognitive impairment, not able to tell you why they're there, not able to tell you the names of their children, that kind of thing, or if you got a diagnosis. And capacity assessment in this context, I think we're mostly referring to a medical professional doing a capacity assessment. Got some concerns about those, so I won't talk about those in a minute, but this is where you're bringing in yet more evidence, probably about as strong as evidence as the strongest evidence you could get of capacity is going to be a physician or medical professional saying, hey, I assessed them. Seems like they have the ability to handle their finances. Okay. So with medical assessments, some are good, like everything in life. Some are good and some are bad, or I should say less good. Some places like the UCSF Memory Clinic, I know does great assessments. I've sat with doctors in that clinic and watched them do assessments, and they're comprehensive. And it's more than just asking those questions on a mini mental. They have them perform functions. There's like puzzles and things like that. And they give you a multi-page analysis of their capacity on all sorts of different measures. Very cool. But in other cases, it might be a doctor going into a nursing home with 30 patients to see, and they've got 90 minutes, and they go into the resident's room and they ask 3 questions, and then they say capacity or no capacity. So I would call those not a very good assessment. Next slide, please. So some concerns about physician assessments, and this is, and on one hand, we want a physician assessment in these cases where we're trying to build up our file to demonstrate that this client had the ability to do what we're helping them do. But on the other hand, when we're talking about taking away people's rights based on a physician assessment, I have a lot of concerns, and here's where they come up. Doctors very rarely get any training on this stuff in medical school or in any of their internships or anything like that. Very difficult to test for capacity. There's no like antigen where you do a blood test and you say, oh, it's positive for capacity. It would be nice if we did, but it's definitely a term of art. Yeah, all these potential problems. And this is a big one. That last bullet point, you want to please the person seeking assistance. I've seen this from a number of physicians where it depends on who's asking them on whether they determine the person has capacity or not. I've had cases where family member calls, doctor says, hey, can you assess mom's capacity? Okay. And they say, capacity's good. And then the son or daughter calls back and says, no, oh, I'm sorry, it's the opposite. They'll say they have dementia. And then the son or daughter will say, no, we need you to find that they don't have dementia because they're going into a facility that doesn't take people with dementia. And then the physician would change their assessment and check the other box. No, it's just a mild cognitive impairment, not a major neurocognitive impairment. So you have to be really careful. Physicians are human and fallible in many ways, but one of the ways that they're very fallible is they want to help the person who's in front of them. And a lot of times the person in front of them is not their patient. It's the son or daughter or other party who's trying to arrange the assessment and get the document that the physician's going to produce. Next slide, please. And if you need a study, an academic study that demonstrates that physician capacity assessments are not all that reliable, here is one. It's from Daniel Marson. It's from 1997. I don't know of any newer ones, but it's pretty good. He had 5 different physicians who all claimed that they were very experienced in dealing with people with dementia and making capacity assessments. He had them watch 29 different patients with Alzheimer's disease be asked a series of questions. So the patients were asked questions off of a script that was recorded, and then the doctors watched those video recordings. And at the end of each patient's interview, they would say capacity yes or capacity no. And you'll see in 44% of the cases, at least one of the 5 physicians said yes capacity and one said no capacity. So there was a lot of disagreement. In almost half the cases, there was some disagreement among the physicians. Now you see, Dr. Marson did a subsequent study where he gave all the physicians a uniform definition of capacity. The first study, he just said, do they have capacity? And left it up to the physician on what capacity meant. When he gave them a uniform definition, there was more agreement, but still, in a quarter of the cases, there was disagreement. Okay, next slide, please. Okay, so there's lots of ways to set clients up for assistance in the future if you expect that their capacity may diminish over time. Maybe they do have a diagnosis. of dementia, and it's a very progressive disease, and you know, a year from now, they're not going to have as much capacity as they do now. And 2 years from now, they'll have even less. So there's ways to anticipate that. Definitely estate planning is really important. We're going to talk a little bit about the retainer agreement and the provisions you could have in your retainer agreement. Okay, let's do this hypo. Clara again. She is a caregiver for a long time, 5 years. They become very close. She has 2 kids. They're not very close. Her current trust says, hey, I want all my assets divided in equal shares to my children. And she comes to you and says, I would like to give everything to my caregiver. What do you think? Do you just say, oh, yeah, sure, whatever you want, Clara? Here's your trust amendment, leaving everything to the caregiver. No, I think this is a common scenario. It might not be the caregiver, it might be a different family member, it may be the new boyfriend. Um, this is written really well, this hypo. I like it because 5 years to me establishes a pretty potentially deep relationship. We could have said 5 weeks and made it a lot easier. Like, there's no way you're doing that without substantial evidence of capacity. And maybe even if you have substantial evidence of capacity, you don't want the headaches of doing this because you know there's a high risk that these two children are going to challenge the trust terms when Clara passes away. So that'd be an easy case. But here we got 5 years. And Arabelle, isn't there some statutory limitations already on leaving estates to professional caregivers?
Yeah, there's a presumption of undue influence. I
Yeah.
forgot the probate code. It's on 21 something. And so what would happen is that the donee would have to prove that it's not undue influence. So that there's a burden shifting.
And that's for estate planning,
Yeah.
not just gifts.
Yes, it's for estate planning. So donative transfers in the estate planning context, or so I think
Okay.
it's gifts too. So
Yeah, so
title to property.
so the law already creates a presumption of looking askance at this or side-eyed at this transaction. So this is one of those cases where you're going to engage maybe all of those tools. You're going to meet with Clara alone, maybe multiple meetings to make sure that her preferences stay stable over time, or her wishes stay stable. You might want to try to get permission from Clara to inform her children that this is happening so that there's a full discussion. It's not a surprise, with client's consent, but you could try to get that. Maybe a capacity assessment from a professional, maybe you do a mini mental, all those kinds of things. You say, all right, I've got your information. I'm going to do a draft. I'm going to have you come in. You're going to read the draft, and then we'll set up a third appointment for you to actually sign it and make multiple appointments. There's lots of tools you could do here. But really, if this caregiver has provided incredible care and has this great relationship, and the 2 children aren't really part of Clara's life, it could make some sense.
Yeah. So the probate code is actually probate code 21380.
Okay.
Yeah.
All right. Next slide, please. All right. Here's where we get into some stuff where I get a little fired up. So we've referenced, I think, at least indirectly, that the model rules on the American Bar Association it says you represent people with cognitive disabilities as best you can, the same way you would any other clients, that you make reasonable accommodations. But there's another part of this rule that says if you think the client has a cognitive impairment and are making really bad decisions that could hurt them, you can take protective action without their consent. So you can go behind their back and in this situation potentially engage a conservatorship petition or call adult protective services and get them involved even after your client has said, I don't want that. So Model Rule 1.14 allows that. California has never adopted 1.14. There's been multiple efforts to get California to adopt Model Rule 1.14. The last version was a watered down version of 1.14 where it said, hey, if you put in your retainer agreement, if a lawyer puts in their retainer agreement, that you could take protective action without their consent. If there's ever a time where you think they're making terrible decisions and they lack capacity, you could enforce that. You could, if that's in the retainer agreement, you could now take protective action. Your client agreed to waive their rights to confidentiality in advance. That was rejected by the state Supreme Court. The state Supreme Court they have to approve all the changes in the rules of professional conduct for lawyers in California. And they were given a list of over 100 changes to those rules, and they approved all of them except that one. So I think it was pretty clear that the state Supreme Court did not like the idea of advanced waivers of confidentiality with lawyers. But then this COPRAC opinion came out, 13-002, that said, well, in the state bar's opinion, the current rules allow for pre-waivers of confidentiality. So this really pisses me off. They went to the state Supreme Court and said, can we change this rule? And the Supreme Court said no. So then the state bar went back and said, oh, we didn't have to change the rule. The current rules allow for this. And I just disagree, to put it mildly. So in our position, in CANHR's position, and the position of some other legal services organizations that represent people with disabilities, you have to give the client a chance to object to your breaching their confidentiality. I don't think an advance waiver, I mean, years could go by, and that client's not going to remember ever having signed an advance waiver. And do they even know what they were waiving? Can they know what they're going to waive in advance? Because they don't know what the situation's going to be. The kind of information that the attorney's going to want to reveal is unknown to both the attorney and the client at the time they sign this waiver. So can it be a real knowing waiver if they don't know the circumstances and context of the information that's going to be provided to third parties? I just think it's slimy, to be honest with you. And I know there's reasonable people have different opinions about this. The idea of helping the client includes, or I guess some lawyers say my duty is to be a good human being supersedes my duty to be a good lawyer. And if I think this person's let's take the Clara situation. It's not a caregiver. It's a guy she met at the bank 2 days ago, who she says is the long lost love of her life, or it's the reincarnation of her deceased husband. And she wants to give all of her money to him now. She wants to sign a power of attorney giving him access to all of her accounts right now. You can, of course, refuse to do that and say, I don't think this is a good idea. But if she says, all right, well, I'm going to go, my new boyfriend here is going to get a form off the internet and we'll sign it there. I'll sign it and get a notary to witness it. And they leave, they walk out, and you're like, oh my God, this is going to potentially end up really bad for Clara. What do you do? There's actually a few things you could do, but there's a point here that, in some cases you might want to be able to call adult protective services and get some third party to intervene, or maybe her daughter or one of her other children, to get them to intervene in this situation. Contact the bank, for example. So there's definitely competing values here. I just don't like the way this was done. I don't think we had the full debate about the benefits and costs of having a policy that allows attorneys to put advance waivers of confidentiality in their retainer agreements, and then execute on them without telling their client in advance that that's what they're doing. All right, next slide. Okay, one last hypothetical. This gives me one last concept I want to cover, which is the difference between consent and assent, or failure to object. I don't like the way this hypo is exactly. I wish it would say her daughter does want to get involved. Because then that way we have a clear situation where I think you have a mandate as a legal services provider to assist the older adult. Even if she doesn't have the capacity to retain you, to sign a retainer agreement, in my experience, we wouldn't require a retainer agreement just to write a letter on her behalf to get a security deposit refund. This, I think, is a very low risk legal representation. She's already moved out. She needs, $1,000 security deposit. Landlord's not paying it. You write the landlord a letter, say, hey, pay up. You owe this money. There's not a lot of downside risk to that. I don't think the landlord's really gonna be able to punish the older adult. If the older adult objects and says, I don't want you, I don't want to make any waves here, just don't write the letter, then of course you're not going to do it. But if you can't get a strong yes, a knowing authorization to pursue the security deposit, I would think the daughter or power of attorney here could authorize it. Now, if the daughter doesn't want to get involved, my question is like, how did this person end up in my office? Is there a friend who's trying to help? Is there a social services person, case manager type who's trying to help? And then can you do the next slide?
Yeah.
Arabelle? So with consent, you can obviously represent this client, but to me, as a legal services provider who's not getting paid, if you're getting paid to write the letter, there could be some conflict there, and I would be a lot less likely to write the letter. But I'm legal services, I'm not getting paid to write the letter. I think it's just to her obvious benefit that she gets her security deposit back to get that additional money. So I'm probably going to write the letter, even if I don't have consent. I have more of a failure to object. So I like to throw that in there because that happens sometimes. All right. That is the end of the presentation. Anything you want to add, Arabelle?
No, I think we've covered everything.
Any
Ready for-
questions from the
yeah, ready for
audience?
questions.
Don't be shy. You can challenge assumptions I made. You can tell me that I was crazy when I said this or that. That maybe I lack capacity to provide these presentations.
Here's a question. Have you worked with a client who has diminished capacity, no POA or no conservatorship, and monolingual and specific language? If so, how did you go about assisting the client?
Oh yeah. Yeah, for sure. Again, it's like, how do they end up calling for assistance? If it's the client themselves, we probably had someone in my office who could speak that language, and that's who they're going to work with, or they're going to be in the room with me. In the other situation, it's probably a third party that's calling on the client's behalf, and they're going to come in. And, we have to worry about the Dianas of the world. Do they have an interest in the case and providing that service? And then there's also like Arabelle had in the slide, different technologies that you could use to assist in the representation and the communication. And then there's also, I think to legal services organizations, there's like really low cost or no cost translator services that are provided by the state, some state agencies, maybe. It's been a while, but I think they're available.
Right, over the phone? I don't know if it's changed. Like
Yeah,
you could
over the
call it,
phone.
yeah, I think that they have
Like you have
that.
to set it up in advance.
Yeah. And again, like with diminished capacity, it depends on what type of like what they need, right? So there's what that slide about what Tony discussed about testamentary capacity versus contractual capacity. So you really have to, I mean, just because someone it has diminished capacity, I mean, it's a spectrum. Like it could be early dementia where they are able to understand, simple explanations, or, they can enter into, or they're able to create a will. So testamentary capacity.
Yeah, and I mean, so I did a very high volume legal services practice in San Diego for 6 years, all elder stuff. And I'll tell you, I had some clients that I couldn't represent them. The capacity was just too limited. I couldn't get any feel for whether they really wanted my assistance or not. And it was stuff where it wasn't just like getting a security deposit back. It was more complicated than that. There was some downside to it. But to me, that's the exception, not the rule. The rule was even when I had indications that there was diminished capacity, there was still a fair amount of capacity to work with. And I've given this example in other presentations. I once represented a person who could only blink answers to questions yes or no, and it took a long time, but we were able, and he understood what we were talking about. He was a reliable historian and other things. Just couldn't communicate with his mouth, had to use his eyes. I had one client who he wiggled his pinky finger, massive stroke. Um, he would wiggle his pinky finger to communicate, and his daughter and him had her down where she knew she was really helpful in that case.
There's another question. Any advice for APS regarding a family that keeps using the elder going back and forth and changing the POA between family members? Oh my God. Yeah.
The worst cases are the family fights. And I tell people all the time, you're not going to have a winner. It's just going to be who loses less, because when the family's fighting, there's almost never a declared winner. It depends about the circumstance of the individual case. It's really hard. I think ultimately, if that's happening, it might best be served to go to conservatorship, and there just to be a court finding that this is the decision maker going forward. But I'll let you know, in these cases where the family's fighting in conservatorship, a lot of times the judges are like, I don't want anything to do with this. I'm going to name third party professional fiduciary as the conservator or the public guardian.
Yeah.
I don't have to deal with this family coming into my court every week. Yeah. So, and when you tell that to family members, sometimes they're chastened, like, okay, maybe we can get along. Mediation is another option potentially, although everyone always tells me with the family disputes, mediation never works.
Yeah, I agree with Tony. I think they're likely going to appoint a private fiduciary, professional fiduciary, and or somebody on their panel, on the courts panel. And a lot of times families realize that there's costs associated with that, managing the estate, especially if it's conservatorship of the estate. And so once they realize that all that money that's in the elder's estate is going to, it goes towards payment of the fiduciary, and their inheritance go down, they end up fighting again in court. And it's like a prolonged process, unfortunately, until the older adult dies.
All right. Thanks for the questions.
Okay, yeah. So I have a question. We have a client, she's 80 years old, and she has 2 sons, few grandchildren, but she's willing to put her house just for under one granddaughter. And we talked to her, she seemed okay. There is no like any problem with her. So I just want to make sure that would it be okay if we just leave the house under like one grandkid, even if she has kids like other sons, grandchildren?
If that's what she wants, that's fine. It's one of those things where you can expect higher likelihood of challenge than you would in your
Mhm.
average case. So you want to have the capacity locked down as much as
Yeah.
possible. Lots of extemporaneous notes of your meetings, maybe a clinical assessment if there's a lot of current concern about capacity. Yeah, I mean, it's her house.
Yeah, and if it is like an estate plan, what a lot of estate planners do when there is a question is to get a certificate of independent review. So a third party, like another attorney with experience, having their own assessment, interviewing the older adult. That way, usually when the judge sees that, that's another evidence that the person had capacity, if after they died, when it's administered, that was what's called a settler's intent or testator's intent to transfer it to the granddaughter.
Oh,
I'll
okay.
tell
Thank
you
you so
a
much.
quick personal story in this regard. My grandparents, they were leaving everything equal to all the kids. My grandpa died. My grandma changed the estate planning documents. It was a family of 8 kids. And she wanted to leave the house, which is her major asset, to two of her sons, the 2 sons that never really had traction in life in terms of a career. And I said, Grandma, I think this is a really bad idea, but she would consult with me. I didn't do the estate plan, but we talked about it. I don't think it's a good idea, but hey, it's if it's what you want, even though it was different from what the estate plan that she had coordinated with my grandfather. Ultimately, she passed away. She leaves the house to her 2 sons. That's like almost, this is 18 years ago. I was just in San Diego with a bunch of my aunts and uncles getting together, my cousins and stuff. And there is still significant resentment from the rest of the siblings. They say, geez, we're the ones who worked hard and they screwed around their whole lives. And they're the ones who got rewarded with the house. And the house is all run down now and blah, 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 blah. So you just make sure that they understand the full implications of how these things can go. But ultimately, if you feel like they got the gist of it, they can do it.
Okay, thank you so much.
Oh, the one thing on that too, if the goal is like, I'm going to leave it to this one grandkid who will then distribute it in equal shares to all these people, that's a high degree of trust.
Yeah. But make sure if you put it in the document, so
You can
that
put that in
way,
the
yeah.
document. Yeah.
Or
Just make
even,
them the executor, the trustee.
yeah. And even
Trustee.
then, like if it is one kid, you could also explain, I've excluded so and so because, they're independent. You can actually do that in the trust documents or in the will.
Yeah, more specificity is good.
Yeah.
All right.
Thank you
Thanks
so
for this.
much. Thank you, Tony and Arabelle. It was wonderful. Thank you, everyone, for attending our August Elder Abuse Task Force. And just a quick reminder, when you log off, a survey will be prompted. If you could fill that out, that would help us a lot. It should take less than 2 minutes. But thank you, everyone, for attending.